We're here to protect the liberty in the Constitution from the democratic excess.
Absolutely, and so that was not my intention at all.
These books are fine, but in another community with a different set of values, they're not. I wonder if we're going to have a real problem in terms of people with different values not being able to have a say in their local community.
Coerced to attend, indoctrinated, and then...
Thank you, counsel.
Thank you.
The case is submitted.
We have the Supreme Court hearing the oral arguments on a reading of LGBTQ books in public schools happening right now. So let's jip in on this and see if there's anything good right now. Otherwise, we'll get an update on the story and come back.
There may be circumstances that give rise to a coercion, fully recognizing that exposure to ideas, even if they offend religious beliefs, do not qualify as a burden for free exercise purposes.
Thank you. Justice Gorsuch?
I just want to make sure I understand a few fact things and then a law question. What age do you in Montgomery County teach students normally about human sexuality?
I think that it begins in either 4th or 5th grade.
The human sexuality class?
The family life and human sexuality curriculum.
Okay.
I'm not entirely sure.
Starts in 4th or 5th grade, you think?
So.
Is there anything you can point us to in the record on that?
I don't think so.
Okay. And second, these books are being used in English class.
The division between English class and other things in a 2nd grade classroom doesn't really exist. You're sort of in a room with a teacher and sometimes...
No, I appreciate that. I went to 2nd grade too.
Yeah.
But it's part of the English curriculum that these books are being used in. I thought that was...
Yeah, I'm not fighting the premise. I'm just saying that
it's not the math class.
It is not.
It's not the human sexuality class.
It is certainly not the human sexuality class. Yeah. I'm just sort of fighting the premise that there's a neat distinction.
Okay. And they're being used in English language instruction at age 3, some of them.
So Pride Puppy was the book that was used for the pre-kindergarten curriculum. That's no longer in the curriculum.
That's the one where they are supposed to look for the leather and things and bondage, things like that.
It's not bondage. It's a woman in a leather...
Sex worker, right?
No, that's not correct. No.
Gosh, I read it.
It's a drag queen and
drag queen and drag
correct.
queen.
The leather that they're pointing to is a woman in a leather jacket, and one of the words is drag queen in the search.
And they're supposed to look for those.
It is an option at the end of the book, correct?
Yeah, okay.
Yeah. Wow, he got mad.
And
or she or they.
You've included these in the English language curriculum rather than the human sexuality curriculum to influence students. Is that fair? That's what the district court found. Do you agree with that? I think
to the extent the district court found that it was to influence them towards civility. The natural consequence of being exposed
Whatever, but to influence them.
In the manner that I just mentioned, yes.
Towards civility, not towards
and
LGBTQ-IXB.
Responding to parents who are concerned, you agree that there was some intemperate language used?
I don't know that those were responding to parents who were concerned. This was after the fact for most of these comments, and this was in a very public setting, which obviously got heated, and some intemperate comments were used, certainly.
Yeah. And I wanted to understand your context that you were giving about the statement that some Muslim families, it's unfortunate that this issue puts some Muslim families on the same side of an issue as white supremacists and outright bigots.
Whoa!
I think in response to Justice Sotomayor, you were trying to give some context to that?
I don't think I was speaking directly about that comment. I think that comment was given or was made in June, which was several months after the decision to withdraw the opt-outs was made. I don't have context for that statement, no.
Okay. And then the legal question. Why isn't discrimination against religion a burden on religion? If a state, now this is hypothetical, not moving away from the record.
That's why.
If state actors intentionally discriminate against religion, what secular purpose, valid secular purpose could that serve?
Because they hate your religion.
How wouldn't that be a burden?
They don't find it valid.
I don't
for society.
know. I mean, it depends on the hypothetical, what the state is doing, and whether there's a secular purpose. That's hard to imagine one. But if the state is discriminating
against Muslims or Catholics or Protestants or whatever,
I think this court has recognized that when an enactment that discriminates on its face or has recognized with respect to an enactment that discriminates on its face, it is intrinsically coercive. That's how the court has performed the burden inquiry. If you are privileging one religion over another, you are coercing people to subscribe to that particular set of beliefs in order to get...
So that's a burden?
Yeah, absolutely.
Okay. Thank you.
Thank you.
Mr. Kavanaugh?
A few things. On exposure, you've used that term, I believe, to include not just exposure in the sense of the book on the shelf, but also the communication of those ideas by the teacher in the classroom.
Correct.
And that's not usually, I think, what we think of as exposure as opposed to instruction. But
the question presented is about participation in instruction, which was precisely one of the things that the Barnetts objected to in being present for the flag ceremony. But I think it's analogous to Kennedy, Kennedy, right? The question there was whether people were merely exposed to Coach Kennedy's prayer, even though the court acknowledged that people might see it, people might hear it, and people might be offended by the content of it.
And on Justice Kagan's question about no lines, I took that to be the position of petitioners in the United States with respect to burden, in the sense that you can have you can claim a religious objection or burden to lots of different things, and people do, but that the line drawing occurs when you do the strict scrutiny analysis. Is that not your understanding?
I don't know what you're asking, if it's my understanding of, but let me try to answer it this way.
Is that your understanding of their position? In other words, that they do draw lines, but it's at the strict scrutiny stage.
Well, the question presented to the court is obviously limited to burden, and what I understood Justice Kagan's exchange with Petitioner's Counsel to reflect is that there is no way to draw a line once you are relying on the petitioner.
As to substantial burden, but once you get to strict scrutiny, as some of our cases reveal, Social Security numbers, et cetera, there is line drawing once you do that. In other words, just because you have a religious objection to something doesn't mean you win. You agree with that, I think, in our case law?
Yeah, absolutely. Though in Bowen, the court stopped at the burden inquiry, at least with respect to the government's own use of the Social Security number.
And you've mentioned a few times that the school board was democratically elected, democratically controlled, and being on the school board is a hard job, so, we all respect that. But, that can't be the end of it, right?
Absolutely not. No. And I didn't mean
liberty, we're here to protect the liberty in the Constitution from the democratic excess.
Absolutely. And so that was not my intention at all. It was to respond to a specific question about what options parents have. And among them, I think, is wresting control of the school board, implementing their preferred policies, or participating even in the curriculum selection process.
And then I don't think you answered this, or maybe we got past it last time. Are you aware of any other county or city school board that has something similar to what's going on here?
I'm not, but I think that the other side of the ledger is overstated, because what is described in the amicus briefs about what other school boards in other states do is limited to what we traditionally consider health education. So I'm not certain that there's a large number of other states or county school boards that allow opt-outs from any curriculum for any reason.
And then last point, just a comment, and you can respond to it as you want, but Maryland was founded on religious liberty and religious tolerance, haven for Catholics escaping persecution in England.
Yeah, that was a long time ago, Judge.
Going back to 1649, I'm sure you're aware of this history. And Montgomery County has been a beacon of that religious liberty for all these years, with strong Catholic population, a substantial Jewish population, lots of different Protestant. I mean, you drive down any Connecticut Avenue or George Avenue, you see building after religious building. And I guess I'm surprised, given this is the hill we're going to die on, in terms of not respecting religious liberty given that history. And so when history comes up, I just want to give you a chance to respond to how you situate that in Maryland and Montgomery County's history.
That's their new
Every
ideology.
school board walks a tightrope, as this court has recognized and other courts have recognized. It's a difficult job balancing the interests of a diverse community. Montgomery County Public Schools are the most religiously diverse in the country. There may be different ways to handle this under other circumstances. Montgomery County did its best under these circumstances, given their curricular goals. That seems to me a fundamentally different question, and it's an important one, but it is a fundamentally different question about whether there's a constitutional right to opt your child out of curriculum that you deem religiously offensive.
Thank you. It's a tough case to argue. I appreciate it. Thank you.
Justice Barrett?
I just want to ask you a couple questions about the instructional materials. So part of the conversation today has been about exposure and whether this is about teaching civility. And so I just wanted to read you a couple of things from the instructional materials to get your reaction of how, if at all, this plays into the analysis. So I don't understand petitioners to be arguing that, there was an objection to being taught respect and kindness to those who have different beliefs. I understood them to be more focused on things like, this is an instruction to the teacher. If a student observes that a girl can only like boys because she's a girl, the board suggested that the teacher disrupt the student's either-or thinking by saying something like, actually, people of any gender can like whoever they like. Or on the transgender issue, when we're born, people make a guess about our gender and label us boy or girl based on our body parts. Sometimes they're right, sometimes they're wrong. When someone's transgender, they guess wrong. When someone's cisgender, they guessed right. So, it's kind of along those things, which seem to be more about influence, right, and shaping of ideas, and less about communicating respect, because it's less about communicating respect for those, who are transgender, who are gay, and more about how to think about sexuality. What is your take on that
Commandeering.
and how we think about this, whether this really is just about exposure and civility and learning to function in a multicultural and diverse society, and how much of it is about influence, or as petitioners would say, indoctrination.
Certainly. I think what you've quoted, Your Honor, are suggested responses or proposed responses for age-appropriate ways to respond to questions that may arise in response to these texts or otherwise. The same response about disrupt the either-or thinking is given when someone says dresses are for girls, boys can't paint their nails, those are boy toys. These are simply ways of contextualizing the information that's being learned and to give students the predicates for being able to respect each other. The express directive from the school is you don't need to understand your peers, you don't need to agree with them, you don't need to affirm with them, but you do need to treat them with respect. When ensuring that that goal is met in the classroom has the incidental sort of implication of answering a direct question about what it means to be transgender, that's an option that's offered to a teacher. There are certainly under certain circumstances where use of these materials or different comments, if a teacher were to say something pejorative or negative or begin to treat students differently in terms of allocation of sort of resources in the classroom based on how they responded to that.
That's not what Amy was
referencing. That's a coercion
referencing.
claim. But simply explaining to students what fundamental concepts are so that they can treat each other with respect, I think, is no different than...
Well, but those things that I read were more than about respect. It was more about kind of what I was talking with you about before, like 2 + 2 is 4. Like, this is how it is.
Yep.
You know, gender is not something that can be identified at birth, for example. So, I mean, I guess that is one way of teaching respect, because it's saying, you know, it's validating the other worldview here, the one that's different from petitioners, by saying, no, this is right. This is how we should understand that. And so that is why you should respect and treat with kindness. Or one could say, I understand, and some of the instructional materials did frame it this way, the way I'm about to say, which is you might not agree or this might be different, but we have to respect and treat everyone with kindness. So I don't understand petitioners to be objecting to the latter kinds of statements. I understand them to be objecting to the this is the way it is kind of statements.
I understand them to be objecting to all of it, including just using the books with none of those materials. The only
I agree. Sorry.
Yeah.
I'm just talking about the instructional.
Oh, I'm sorry.
Yeah.
So I think you and I see it the same way. With respect to the instructional materials, though, if we are in a world where you and I are parsing which of these materials are impermissible or give rise to a burden on the impermissible side of the line from the others, the record is woefully underdeveloped on that point. These books were in use for 9 months before petitioners sued. There's not a single factual statement in any of these declarations or anything else that explains how these supporting materials were used. It may well be the case that no second grade teacher ever uttered the words that you just quoted.
But I think what petitioners said in their argument is that we're at the preliminary injunction stage, and the instructional materials were given to the teachers, and I think the instructional materials reflect what the board hoped to accomplish by introducing these books into the classroom. And so what they're saying is we don't want to wait for the teacher to say this to our child. Our whole point is we know that this is part of the board's curricular choice. We know that these are the instructional materials that are given to the teachers, and we don't want our child to be exposed to that. And so, frankly, if they got the injunction they were asking for, then they would never be uttered.
Yeah, I don't dispute anything you're saying. I think the relevant inquiry takes account of that temporal dimension for seeking essentially a pre-enforcement challenge here. It would not have been difficult if this was being used rampantly and impermissibly in classrooms for them to find a declarant who didn't need to be a petitioner to say this is what's going on in this classroom. There are hundreds.
But they didn't have to have that for PI.
They have to show a reasonable likelihood of success on the merits, and to say...
And it's not a reasonable likelihood of success, or that this injury is imminent, to say this is what teachers have been given as a suggested discussion guide?
This was distributed to 130 teachers in August of 2022 for teachers who voluntarily attended one of these materials and was otherwise made generally available. It's not a script. You're not required to answer that particular question if it arises with that particular verbatim response. I don't know any second grade teacher who could. So I do think some more particularized showing is required for someone to prevail even at the preliminary injunctions.
So last question.
Look at all the other
do you
injunctions
agree that it was
Trump.
the purpose of the board to try to disrupt students' thinking and make them to disrupt their thinking and have them not see gender as binary, basically accept LGBTQ relationships and ideas in this way, kind of the ways that I just read?
I think the goal, I want to answer your question directly. I think the goal was to teach mutual respect. I think to the extent that students were unable to display mutual respect for their peers without having some further understanding that boys can play with girls' toys, for example, then that was absolutely part of the curriculum.
So it was part of the curriculum to teach them that boys can be girls or boys can, or that your pronouns can change depending on how you feel one day to the next. That was part of the goal.
So I think you're
yes.
quoting from a book that was not part of the curriculum, but let me just set that aside.
Well, I thought that was I might be blending together
blend
in
together.
my mind. I thought it was from the Allies book.
I don't think.
Intersection
I don't think so. I
Allies?
think there may be a quotation from the
Penelope
teacher's
is
user guide at the end.
Okay. Oh, at the
But-
end of Intersection Allies?
Yeah, it may be, though I recall it being a quote from anyone else. It doesn't matter.
Yeah.
So I think the way that these support materials are framed are to help a teacher answer a student's question when he says, in this book, there's a boy who says that he's a girl. How can you be a girl when you were born a boy? And it's one resource to provide teachers with an answer to that question. The alternative was to provide nothing to the teachers, which I think would abdicate the school board's responsibility to ensure that their teachers are equipped to do their job.
Thank you.
Yeah,
Justice
okay.
Jackson?
So two quick final points. For those of us who are trying to get a handle on the potential administrative challenges of notice and opt-out rights, would you be recommending that we look at the School Superintendents Association amicus brief? Because I thought that's what they were focusing on, that here are actual potential administrative challenges. Is that one of
I
the
think
resources?
that resource is well worthwhile, I think, for two reasons. The first is it goes through 40 years of litigation on this, going back to Mozart, and it has, I think, a bulleted list of all of the things that parents have raised, even under this sort of ancien regime where these were not treated as burdens. And second, I think it makes a persuasive case about the administrability of the isolated family life and health education opt-ins.
All right. And finally, as I understand your response to Justice Alito's question about what religious parents are supposed to do, I understood you to say that parents with religious objections can vote for members of the school board, they can go to school board meetings, they can object to the curriculum. Maybe the school board will
While they
agree
steal
with
your
them,
kids
at
from
which
you.
point we don't have a problem, or maybe they won't. And if they don't agree, those parents in Montgomery County, at least, can pull their students out of school and homeschool them or send them somewhere else.
Yeah, that's going to be the answer.
But under petitioner's rule, as I understand it, parents who lose through the democratic process, who are not able to get the curriculum tailored in
Have to
their
be indoctrinated.
local school boards the way that they would like, would have another option. And that option would be to go to federal court. And so instead of having democratically elected representatives and experts in the field making the decision about which books should be taught to kids in the classroom, you have federal judges flipping through the picture books and deciding whether these are appropriate for 5-year-olds. I mean, I don't know how we would even go about that. It seems pretty troubling because ordinarily public education has been the subject of local control. We typically lack this specialized knowledge and experience to know what should be taught to kids and how, and to look at the instruction manual and say, is this a proper response? So that's kind of a concern, I think. And I also think it's a concern that these questions don't always have one answer.
You have a question?
Maybe in one community, one set of values, these books are fine. But in another community with a different set of values, they're not. And it's sort of the local process that allows
states' rights
that to
person now?
cash out where people live, that allow their values to get expressed in the context of schools. And if we constitutionalize that, I wonder if we're going to have a real problem in terms of people with different values not being able to have a say in their local community as to what their
Do you
kids
have
learn.
a question, Judge?
I agree with all of that, and I think it goes back to Justice Kagan's point earlier, where I think you described it as a sort of hydraulic pressure, which is once you constitutionalize it, I think you'll see an entirely different generation of challenges to school curriculum. So the last 40 years are the natural experiment where courts used burden as a meaningful filtering system for mere exposure to offensive ideas in the classroom versus where the presentation of the curriculum was becoming impermissibly coercive. I grant that there are limits on what schools can do with their time when students are in the classroom, but exposing them to different ideas, even ideas that offend their family's religious beliefs or make it more difficult for their families to raise them in the faith, simply doesn't qualify as a burden for the purposes in front of us. And I think that burden analysis always has to be carried out in light of the special characteristics of the school environment, which I think, Justice Jackson, is precisely what you're getting at. A very important part of the special characteristics of the school environment are the fact that federal courts are not meant to sit as school boards in deciding these curriculum disputes. And I think my colloquy with Justice Alito illustrates that. If the question really turns on whether one reads Uncle Bobby's Wedding one way versus the other way, courts are going to be enmeshed in the most fine-grained disputes about how to treat curricular materials.
Thank you.
Thank you, counsel. Rebuttal, Mr. Baxter?
I'd like to start with 4 corrections to the record. First, the book, What Are Your Words, is the book where the children are told that their pronouns can change day to day. At 80, and this is in the district court's opinion, at 80A in the Cert Appendix Note 1, the district court found that this book and others were recommended. There are certain books that were part of this curriculum, but there are potentially hundreds of others that the board says you can use as part of this. There was a question about why this, why isn't there more evidence from early on? Because there were opt-outs, and the board insisted over and over that there were opt-outs. We also know that the principal's letter didn't come in until November of 2022, saying that teachers were uncomfortable presenting this material. It was age inappropriate. They didn't want to be talking about romance between 2 kids on the playground, regardless of their sexual orientation. On the question of use, I would refer to 605 in the Cert Appendix, where Hazel, the board's representative, said that they have to be used as part of instruction. 657, when they announced they were blocking the opt-outs, they said teachers must utilize with all students. These books are definitely being read by the teachers as part of the curriculum, and it's also at 63 of the district court transcript. And then also a question about when sex ed starts. The board's and the state's mandated regulation is in the record. It's at pages 62 through 83 of the joint appendix. There you start in pre-K with instruction that parents can, or families can come in all different forms with all different kinds of parents, different kinds of gender identities and expressions. The same things that are being taught through these school books. You can opt out when it comes up during health class, but not during story time, in which there's no instruction about how to use these books to develop
4 to 5 years
characters,
old,
narrative arc, or anything else that you would expect in an English class. This was not a democratic process, withdrawing these overnight, comparing parents to xenophobes and white supremacists. This can't be part of the democratic process. The line drawing problem is on the board's side. I'm confused now about what exposure is. Are you being exposed to the Prophet Muhammad? That's not okay. But if you're being instructed something derogatory about him, can't get an opt-out. What does it mean to be derogatory to someone who is in the 3rd grade? And the 40-year issue of litigation, I think that proves the exact opposite point. If you look at those cases in, for example, the NEA brief, those are Establishment Clause cases. They are curriculum challenges where we agree that the plaintiffs should lose. There are cases where people got relief and still sued, and a lot of them were resolved under strict scrutiny. And half the circuits have never even addressed this question. This is a question of first impression in the 4th Circuit. So there's no sense that these issues are going to create lots of kinds of problems. As far as feasibility, counsel made lots of arguments that are not in the record. This was their burden. The evidence was in their control. They could have put it into the record. It's not there. On a preliminary injunction, they should be held to their burden. We've been doing this for 2 years. Our clients are making great sacrifice to send their kids to private school, to homeschool. They've moved out of the county. They're not knowing what their kids are being taught.
Thank you, counsel.
If the First Amendment means that you can be forced to pay, coerced to attend, indoctrinated, and then...
Thank you, counsel.
Thank you.
The case is submitted.
When the Chief Justice cuts you off, thank you! You're done. All right, so that was a disgusting set of oral arguments. Wow. So that's what they're trying to do to the youth of America. Here is what the backstory is on that case. So we just wrapped up oral arguments. The case is Mahmoud versus Taylor. It's a group of parents, Montgomery County, Maryland. They say that requiring their children to participate in education and instructions that includes LGBTQ+ themes, as we heard, violates their religious beliefs and their First Amendment rights. It is a suburb of Washington, D.C., Montgomery County, largest school district in Maryland, one of the country's most religiously diverse. The dispute before the justices began way back in 2022, when the county approved books featuring LGBTQ characters for inclusion in its language arts curriculum. Now, we just heard that it goes all the way back to pre-K. Some people saying it starts as early as 3. We just saw 3 to 5, let's say, is where they're getting a lot of this. One book used for the children is called Pride Puppy. Tells a story of a puppy that gets lost during a pride parade. Another book tells the story of a girl attending her uncle's same-sex wedding. And in one of the books we heard, they're also trying to identify leather on drag queens. When the county announced in 2023 that it would not allow parents to opt to have their children excused, sorry, you have to sit there and take it. A group of Muslim, Catholic, Ukrainian Orthodox parents went to federal court. They said that the refusal to give them the option to opt out violated their constitutional rights and their ability to instruct their own children on gender, sexuality, and faith according to how they would like it to go. The lower courts rejected their request for an order that would temporarily require the county to notify the parents when the storybooks would be used to give them a chance to opt out. Hey, we're going to read your kids these sick freak stories to try to indoctrinate them, capture them into our ideology, because that's how our ideology grows and expands, is via recruitment. The U.S. Court of Appeals for the Fourth Circuit explained that the threadbare record before it, the parents had not shown that exposure to the storybooks was a violation of their religion. The parents came to the Supreme Court. Justices said we'd hear it. In their brief to the Supreme Court, the parents point to two different Supreme Court cases. They say, 50 years ago, Wisconsin versus Yoder, the justices recognized beyond debate the First Amendment rights of parents to guide the religious future and education of their kids. That means, they say, that under the Free Exercise Clause, they can opt out of instruction that would interfere. In Yoder, same case, the court held that Amish parents did not have to send their children to school after the 8th grade because they believed that doing so conflicted with their religion. Here, the parents say they're just trying to excuse their kids, that's all. We just don't want them to go get this indoctrination. And under the Supreme Court's 1993 decision of another case called Lukumi, the parents continue, the school board's policy is also unconstitutional because it's neither neutral nor generally applicable. The Board of Education, the parents stress, has long allowed notice and opt-outs for any instruction that's related to family life and human sexuality. But by contrast, they say, you have to sit here and eat our trans and gender identity ideology. Moreover, they add, board members have displayed explicit religious hostility to the parents who have objected to the curriculum, calling them white supremacists and xenophobes because you don't love the trans. Now, the Trump administration filed a brief supporting the parents. Sarah Harris, then the acting Solicitor General, told the justices, because the country and the county will not notify the parents before the gay storybooks are used, them an opportunity to opt out, parents can only comply with their religious obligations to their children by withdrawing the children from school altogether. She says that is textbook interference. At least give them notice. The Montgomery, if they have no notice, they've got no option but to pull them out. Otherwise, they're going to be sitting there learning about math, and then they're going to introduce Johnny and Jerry's hot dog party stories. The Montgomery County Board of Education, along with the superintendent of the schools and board members, counter that under the Constitution and the Supreme Court cases interpreting free exercise, the parents must show that either they or their children are being coerced to change their religious beliefs. Well, nobody's forcing you to change it. We're just going to teach your 4-year-old about transgenderism. The Supreme Court, they contend, has never held that when parents opt to send their children to public schools that this is a burden, and the board cautions if you accept their arguments, then people with religious beliefs are going to come in and take over public schools, and then our kids are going to be religious. Oh no. But in any event, the board said the parents have not shown that there's any coercion here, and so we just heard the oral arguments that took place, and I don't know, John Roberts sounded skeptical in the little bit that we heard of him, which was not much. We heard from Gorsuch mostly. Kavanaugh sounded skeptical. Amy Coney Barrett sounded skeptical. She's got a bunch of kids, and the imagery and the themes are disgusting, right? I mean, they're just totally inappropriate for 4, 5, and 6-year-olds, but that's what they are doing out there. And of course, we'll see how the Supreme Court rules when it drops.